Good morning and happy Friday, my friends. Happy Friday. Welcome to the land of make-believe, the land of the upside down, the twilight zone. Today is Friday, August 23rd, 2024. And of course, Judge Cannoni released her decision on a Friday. We've been talking about that for a long time. When is it going to happen? It's going to happen on a Friday, and it's going to happen when I'm on vacation. Mark Bettero's on vacation, but not when Judge Cannoni's on vacation, because she doesn't go on vacation until next week and the week after. But the decision dropped this morning. It's filed, I want to say, 8:26 a.m. Eastern Time. How many of you, show of hands in the chat, have already read the decision? We're going to read it together. We're going to go over it. Mark is not able to join me, but I have some thoughts from him that I will tell you afterwards. And what's the definition of insanity? Doing the same thing over and over and over again and expecting a different result, right? So this time I really thought, all right, I think she's going to do the right thing. She has to do the right thing. This is a constitutional issue. This goes to double jeopardy. This goes to a defendant's right to a fair trial. And yet, for some reason, the Constitution of the United States of America doesn't seem to apply to the laws of the state of Massachusetts. And you guys know it because so many of you live there. So many of you live there. And you know because you tell me all the time. Oh, Kelly Reed is in the house. Good morning, Kelly. Not a great day for the Reed family, I would imagine, but also not one I think that was terribly unexpected. Hence the reason that Marty Weinberg was brought onto the defense team to handle the appeal on this, which I'm sure is already drafted and ready to go. If it's not filed by today or very quickly, I won't be surprised. I would be surprised. I'm sure it's already in the works. I'm sure it's ready to just have a signature, add some quotes in from this decision and order. Off we go to the appellate court in Massachusetts, which I believe is called the SJC. As you know, I'm a New York admitted attorney. I am not a Massachusetts admitted attorney, although Mark Bettero is pro hoc vice in Massachusetts. And in New York, we have 3 levels of courts. We have our lowest court is the Supreme Court, oddly enough. Then we have the appellate division, which is the first appeals court, and then we have the Court of Appeals, which is the highest court in New York State. So in Massachusetts, you guys have the Superior Court, and then you have the SJC, and then do you have a court above that? What's the highest court in Massachusetts? The SJC is the highest judicial court, so you only have 2 levels. You only have 1 appellate court. Okay, well, that's interesting to know. Also, the reason why the judge had advised everyone that that's the reason she was setting a trial date for late January, because she knew this decision was going to be appealed no matter what. But here we are in the upside down of Dedham. The appeals court comes before the SJC in Massachusetts. Okay, good. Thank you. So is this going to leapfrog the appeals court and go to the SJC? I don't know. But in any event, expect an appeal, expect it to be filed tout de suite, and expect us to go over the papers as soon as it drops. How long for the appeals process? Well, I would imagine it's going to have to be an expedited appeal. This is an issue of utmost importance when it comes to double jeopardy of a criminal defendant in a murder case. And the judge, as you know, sticks to a very tight schedule when it comes to at least trial dates. And so she'll want this trial to go ahead, this retrial to go ahead in January. And so likely it will be expedited. But here we are at the end of August, August 23rd. So the retrial date is about 5 months away. Okay. All right. Are you ready? Because I'm here for you. And we're going to vent about this and we're going to talk about this. And it's insane. Aidan Carney also released an interview. I don't know if it was last night. I think it was this morning. So I think I saw it first thing when I woke up with one of the jurors who has spoken to him. We will take a look at that as well. This juror was hesitant to release their name or anything or have a more in-depth interview until after this decision came out, which coincidentally is today. So who knows what Aiden Carney will have in store for us and you later this afternoon or this evening. Yeah, I know. That's why we're here. We're here, Yucca. We're just going to try and keep it classy with regard to the language in the chat because, I don't know, YouTube doesn't like it, and then they shadow ban, and then it's a whole thing. But anyway, here we go. Let's see if I can get this to a proper size for you. Are you ready? This is the memorandum of decision and order on defendant's motion to dismiss the Karen Read case. On June 9th of 2022, a Norfolk County grand jury indicted defendant Karen Read on charges of murder in the second degree. Indictment 1, manslaughter while operating under the influence of alcohol. Indictment 2, and leaving the scene of personal injury and death. Indictment 3, following the death of her boyfriend, John O'Keefe, on January 29th of 2022. Trial on the matter began in April of 2024. There were 8 weeks of evidence and nearly 5 days of deliberations. After the jurors expressed to the court that they were deadlocked for a third time, the court declared a mistrial. The defendant now moves to dismiss the charges for murder in the second degree and leaving the scene of personal injury and death, arguing that retrial would violate the double jeopardy protections of the federal and state constitutions because the jury, in fact, reached a unanimous decision to acquit the defendant on those charges. Alternatively, the defendant argues that dismissal is required because there was no manifest necessity to support the declaration of the mistrial with respect to those charges. After careful consideration, this court concludes that because the defendant was not acquitted of any charges and defense counsel consented to the court's declaration of a mistrial, double jeopardy is not implicated by retrial of the defendant. The motion is therefore denied. And that, my friends, is only page 1 of the decision, which goes on for another 21 pages. So buckle up. Right. You're right, Emma. Bev will never admit this is her fault. Nope. First of all, you're going to see through some of the language in this decision that the judge may be watching my show. I'm just going to say, because I have merch with this quote on it. We're going to get to it. Some of you have already seen it. You've sent it to me. You're like, this is crazy. She must watch your show. Background. On June 25th of 2024, the jury began its deliberations in the defendant's trial. Well, let me just check my sound. Is my sound okay? Because I just want to make sure it's set up to the right mic because I'm traveling and I don't have my... Should be okay, right? All right. Background. I'm going to start that again. June 25th of 2024, the jury began its deliberations in the defendant's trial. In addition to the 3 indictments, the court had instructed the jury to consider 2 lesser included offenses to manslaughter while operating under the influence of alcohol, involuntary manslaughter, and motor vehicle homicide, OUI, liquor, and negligence. On Friday, June 28th of 2024, at approximately 12:10 p.m., the jury foreperson sent a note to the court. It stated, "I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we've been unable to reach a unanimous verdict. The court requested argument from the Commonwealth and the defendant as to whether there had been due and thorough deliberations from the jury. Assistant District Attorney Adam Lally, on behalf of the Commonwealth, argued that the jury had not had sufficient time to deliberate and that therefore it's far too early in the deliberative process to give the jury the WE Rodriguez instruction, footnote 1, which says, the use of the WE Rodriguez instruction is a matter of discretion of the trial judge. We heard that a lot during the trial, all the things that the judge has the discretion and the right to do, including teach the jury the law not instruct them on the law, as most other judges will say. Citing Commonwealth versus Perea, it is the, quote, orthodox approach to dealing with a deadlocked jury, see Commonwealth v. Furman, and, quote, designed to urge the jury to reach a verdict by giving a more serious consideration to opposing points of view. In other states, it's called an Allen charge or a dynamite charge. In Massachusetts, it's called the WE Rodriguez instruction, not to be confused with the WE materials that were handed over by the federal government to the defense in this case, or to both sides in this case, through the WE process in federal court, which is spelled Touhey, and this is TUEY-Rodriguez. He also pointed out that although the note indicated the jury had not yet come to a conclusion, it did not indicate that doing so was not possible. Attorney Yannetti, on behalf of the defendant, disagreed with Mr. Lally's characterization of the note. He argued, the word exhaustive is the word that I think is operative here. The jury is communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. You know, this is a case where the jury has the legal instructions. They've only really asked one question, which was to try and get a report they were not allowed to get. And I think the message has been received that the evidence is closed and they won't get anything more. They've been essentially working nonstop over the last 3 days, over the last 4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the WE Rodriguez model instructions and go from there. The court ruled that given the length of the trial, the number of exhibits and witnesses, the complexity of the issues, and that the jury had only been deliberating for 3 days, deliberations had not been sufficiently due and thorough to warrant a WE Rodriguez instruction. It instructed the jury to continue deliberating. On Monday, July 1st, at approximately 10:45 a.m., the jury sent another note to this court. This note stated, despite our commitment to the duly entrusted in us, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. End quote. The court again requested argument from counsel as to whether there had been due and thorough deliberations. The Commonwealth argued that the jury had been deliberating 22 to 23 hours, but given the length of the trial, number of exhibits and witnesses, and complexity of issues, they had not done a thorough deliberation up to this point. Attorney Yannetti, again, had a vastly different view. He argued, our view is that it's time for the WE Rodriguez instruction. They have come back twice, indicating essentially that they're hopelessly deadlocked, but the content of this latest message is that they have been over all the evidence. The previous message said they did an exhaustive review. This time, they said that they have fundamental disagreements about what the evidence means. It's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they have done that. This is what WE Rodriguez is for. The court agreed that the jury had engaged in due and thorough deliberations, noting that this jury had been extraordinary and it had never seen a note like this from the jury. It therefore provided the jury of the full WE Rodriguez instruction and asked them to return to the deliberations with those instructions in mind. I think there's a typo in there, or it's just grammatically incorrect. I'm going to point every single grammatical error out to you. It should say, it thereafter provided the jury with, not of, the full WE Rodriguez instruction. Footnote 2, which reads in very tiny font, the WE Rodriguez instruction states, Quote, our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking, in all cases, absolute certainty cannot be obtained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with the proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. Which I'm going to break from the document to say that is what they did. But they were told not to fill out any of the sheets until they came to a unanimous decision on all of the counts, remember? Because we went over this a bunch. In conferring together, you are to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their minds is a reasonable one, if it makes no impression on the minds of the other jurors who are equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. I didn't want to let that get by, Kelly, because that's a good one. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. Going back to, this is my cursor on your screen, so please don't, I don't know if you can even see it. Please don't break your TV and send me a bill. Thanks. That same day, at approximately 2:30 p.m., the jury sent another note to the court. The court stated to counsel that the jury was at an impasse. After the jurors filed into the courtroom, the court read the note. Quote, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. After reading this note, the court declared a mistrial and discharged the jury back to the deliberation room to wait for the judge. Counsel remained in the courtroom to discuss an agreeable date to return for a status conference. Thank you, Itchy Withers Horse Rescue, for being a member for a month, who says this won't end anytime soon. They'll drag it out as long as possible. But it's going to an appellate court now, so just know that the appellate court, different judges, different procedures, more of a sense of urgency, perhaps. I mean, after all, this is the murder of a Boston police officer, should we forget? Justice for John O'Keefe, Officer John O'Keefe, and prayers to everyone who misses him, including all of you. Mrs. Bucket, thanks for being a member for 3 months. Chloe Albert's Revenge, good morning. Says, thank you for the super chat. She manipulated the heck out of this trial. She did nothing normal down to ruling on objections. All of this was by design so that her culpability seemed ambiguous. I hope she's watching this. We see you. Clamasus, thanks for the 10. Bev's jury instructions were legally and factually incorrect, causing this mistrial. Karen should not suffer due to her actions. Thanks for going live today. You are the best, Melanie. We are outraged. Oh, we are outraged. Which, by the way, the final edit of the Bang Bang song has me in it saying we are outraged. Love it. Back to the document. On July 8th of 2024, the defendant filed the instant motion to dismiss, supported by affidavits from Attorney Yannetti and co-counsel Attorney Jackson. Attorney Jackson's affidavit stated that on July 2nd, 2024, a juror in the case, Juror A, contacted him. Attorney Jackson was able to identify the person as a deliberating juror based on his or her description of who he or she is, where he or she was seated, and certain identifying information, name and occupation disclosed during the voir dire process. According to Alan Jackson's affidavit, Juror A told him that he or she wished to inform him of the true results of the deliberations because he or she believed those results significantly impact the defendant's rights. Juror A said the jury unanimously agreed that the defendant was not guilty of counts 1 and 3, specifically that the murder charge was, quote, off the table. First Jackson affidavit at paragraph 5. In his affidavit, Attorney Jackson also stated, neither Ms. Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Attorney Yannetti's affidavit averred that on July 3rd of 2024, he received communications from 2 informants who had received information from 2 deliberating jurors in the case. The first informant, Informant B, sent him a screenshot he or she had received from someone else, Intermediary B, of text messages that Intermediary B had purportedly received from a juror, Juror B. Attorney Yannetti averred that he was able to positively identify which juror was Juror B based on a first name given to him from Informant B. In the screenshot, Juror B texted Intermediary B, it was not guilty on second degree, and split in half for the second charge. When the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Yannetti affidavit at paragraph 4. And you may recall that's exactly the way the text message read, although it maybe have been a typo in there. Attorney Yannetti stated that another informant, Informant C, contacted him on July 3rd of 2024. Informant C told him he or she personally knows. All right, Informant C told him he or she personally knows a juror, Juror C, and that Informant C and Juror C have a mutual friend, Intermediary C, who's a current coworker and friend of Juror C. Intermediary C told Informant C via text message that Juror C was a deliberating juror in the case. Intermediary C had a discussion over text message with the Juror C about the experience of being a juror. Intermediary C said that Juror C said that there was no consideration for murder. 2. No consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlocked at 4 no, 8 yes. Yannetti affidavit at paragraph 8. Informant C texted back, interesting. If there was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was confusing. Footnote 3. As noted below, defense counsel argued to the court that the verdict slip for indictment 2, which allowed the foreperson to check guilty for the lesser included offenses, would be confusing for the jury if they decided the defendant was not guilty of all of the lesser included offenses. So far in 6 pages, she's continuing to blame the defense for this result and for her decision. Are you noticing that? Intermediary C texted, "She shouldn't have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing." We've discussed that ad nauseum. Attorney Yannetti stated that based on the description of Juror C he received from Informant C and the description of what Juror C told Intermediary C, he could positively identify that Juror C was a deliberating juror. Attorney Yannetti later filed a supplemental affidavit in support of the defendant's motion to dismiss, wherein he stated that he received an unsolicited phone call from an individual identifying himself or herself as Juror B. Juror B told Attorney Yannetti that he or she was familiar with the affidavit he had previously filed and confirmed the substance of the conversation between Informant B and Intermediary B. Juror B clarified that he or she meant to write, "No one thought she hit him on purpose or even knew that she had hit him." Yannetti supplemental affidavit at paragraph 4. On July 10th of 2024, Attorney Jackson submitted a supplemental affidavit stating on July 8th of 2024, another juror, Juror D, contacted him. He identified this person as a juror by the description of who he or she is, where he or she was seated, and certain identifying information, name and occupation, disclosed during the voir dire process. Juror D told Attorney Jackson that he or she was uncomfortable with how the trial ended. Juror D said that it was very troubling that the entire case ended without the jury being asked about each count, especially count 1 and count 3. Jackson's supplemental affidavit at paragraphs 3 and 4. According to Jackson's supplemental affidavit, Juror D told him that the jury agreed that the defendant was not guilty on counts 1 and 3, that they disagreed solely on count 2's lesser offenses, but that they believed that they were compelled to come to a resolution on all counts before they could or should report verdicts on any counts. I'll break from the document to say, isn't that exactly what the judge told them? And didn't she also tell them during the course of reading them the jury instructions that I'm also going to tell you some things, and if what I tells you disagrees from what I read to you or what you have in your notes, then what I say to you is controlling. I remember that. I need some Twilight Zone emojis in the chat, members, please. Juror D believed that all the jurors would corroborate his or her account. He or she also stated that if necessary, he or she would testify before the court as long as his or her identity remained protected. You can see that these jurors, in addition, I don't know if she's going to address Juror Doe because I didn't have a chance to read this whole thing before I came on with you, so this is a real reaction video from me. Juror Doe is also afraid of retaliation, of being doxxed, of being attacked, being threatened, because they're out there now in the real world, and if they've been watching any YouTube or any social media, they can see what's going on and what's been going on and how both, whatever sides of this case have been attacking each other personally on such various cesspools as Twitter. And I can understand why they would be nervous and afraid to have their information public. And because of that, the judge sealed all of their identities indefinitely. Juror Doe had asked for them to be sealed for, I think, a year. And she had said, and now she says, until further notice. On July 18th of 2024, Attorney Jackson submitted a second supplemental affidavit stating that on July 17th, 2024, he was contacted by another juror, Juror E, who he identified by the description of who he or she is, where he or she was seated, and certain identifying information, name and occupation, disclosed during the voir dire process. Juror E also stated that the jury was unanimous on counts 1 and 3, and that the defendant was not guilty of those charges, and that they were deadlocked on one of the lower charges on count 2. Jackson's second supplemental affidavit at paragraph 5. On August 1 of 2024, the Commonwealth filed a post-trial notice of disclosure stating, okay, so this is interesting. We talked about this too. Lally filed this not as a response to the motion, not as an opposition to the motion, but as just like a regular discovery exchange, which is curious to me. So on August 1st of 2024, the Commonwealth filed a post-trial notice of disclosure stating that ADA Lally had received 2 unsolicited voicemails from an individual identifying themselves as a deliberating juror, stating that the jury had been unanimous on counts 1 and 3. The Commonwealth also received emails from 3 individuals identifying themselves as jurors, stating that they wished to speak anonymously. So they were contacted by 4 of the jurors, which is 1/3 of the jury, the Commonwealth. In response to the emails, the Commonwealth stated that it was ethically prohibited from inquiring as to the substance of the jury deliberations, and that it could not promise confidentiality as it may be required to disclose the substance of any conversation to the defendant or the court, which I call BS on, because there was already an order sealing their identities, right? And in the motion papers, the defense referred to the jurors by letter, A, B, C, D, E. And the Commonwealth could have done the same, but they said, they told these jurors, yeah, no, we can't promise that you won't be doxxed. So what did they do? All 3 jurors declined to comment further with the Commonwealth. Can you blame them? And also, Mr. Lally, when is it that you got these emails from these jurors? Was it before you filed your opposition papers saying that this motion had absolutely no merit? It's not addressed in this order, but inquiring minds really want to know. Because if you had emails from these 3 jurors before you filed that opposition, could it be argued that you intentionally misled the court? Is that an ethical violation, Mr. Lally? Mr. Marcy? Just saying. Let's break for a second before we address the discussion so that we can talk about some questions for a second. Hi, Nina. Thanks for chiming in. To be fair, the defense seemed to be happy about the mistrial, obviously not anymore, and they were also responsible for the jury instructions. Well, both sides in any jury trial submit their proposed jury instructions to the court, and then they are argued and agreed upon. Not agreed upon. I mean, they both have their own jury instructions, both sides, that they want, and then they argue them in front of the judge if there are any bones of contention, and then the judge has the final say on what the instructions are. So it's not like once the judge decides what the instructions are going to be, that they have any real recourse at that point. See what I'm saying? But I understand what you're saying. Thank you, Mandolin Wind, for gifting a membership, and to anyone who received it, welcome. Welcome, welcome. Tiffany Wade, good morning. The world is still watching in shock and horror. And I got your email. I don't know if I responded to you yet, but you're a sweetheart. Thank you for that. Buzzing for Truth, thanks. A member for 7 months. Wow. Did you change your name? Corruption at its finest. I am outraged. Thank you, Jerry Lynn, for becoming a new member. Clinton Nix says, I wonder how and if the jury will respond to this. I'd be outraged. I am sure that they are, and whoever this juror is that has been speaking to Aidan Carney, I'm sure maybe perhaps they will now want to speak out further If there are any other jurors who would like to discuss it with me, I am happy to discuss it with you. My mods will put my email in the chat. Amy in Boston, hello. For 9 months, found you in police off the cuff and never left. Thank you, thank you. YouTube turns, thanks for the 10. Dishonorable Judge Beverly Canone, don't you smell that smell? That smell that's around you? It's a Leonard Skinner reference. Thank you, because you know I sing, I think, in song lyrics, and Leonard Skinner was a favorite of mine all the way back in junior high. Has anyone checked if Beverly Canone gave juror instructions the same way in previous trials? This smells. Thank you for your super chat. Back to the document. On page 8, discussion. The Fifth Amendment to the U.S. Constitution, applicable to the states through the 14th Amendment to the U.S. Constitution and Massachusetts common and statutory law, protect an individual defendant from being twice placed in jeopardy for the same crime. Quoting Perrier v. Commonwealth, v. Commonwealth v. Taylor, quoting Oregon v. Kennedy, the Double Jeopardy Clause affords a criminal defendant a valued right to have his trial completed by a particular tribunal. A defendant is entitled to protection from double jeopardy if there has been some event, such as an acquittal, which terminates the original jeopardy. See Commonwealth v. Heb. Or if a mistrial is entered without the defendant's request or consent, unless there was manifest necessity for the mistrial. Citing Taylor, Heb, quoting Yeager v. the United States. The interest in giving the prosecution one complete opportunity to convict those who have violated its laws justifies treating the jury's inability to reach a verdict as a non-event that does not bar retrial. In her motion to dismiss, the defendant argues that retrial on indictments 1 and 3 would violate the double jeopardy protections of the federal and state constitutions because despite absence of a jury verdict, the jury in fact reached a unanimous decision to acquit her on those charges, or alternatively, because there was no manifest necessity to support the declaration of the mistrial with respect to the charges. After careful consideration, the court concludes that the defendant's arguments are without merit. Shocker? Shocked or not shocked? Acquittal of the defendant is the next heading. The defendant first contends that she was acquitted on indictments 1 and 3, and that therefore retrial is barred based on her attorney's affidavits purporting to reflect statements by jurors that the jury reached a unanimous conclusion that she was not guilty on those charges. Although the statements in the affidavits are from purported jurors who wish to remain anonymous for the purposes of this motion, the court accepts the statements as true and accurate. Footnote 4. While the court accepts the averments as true and accurate, it disagrees with defense counsel's characterization of the statements as strong and uncontradicted. The substance of the conversations directly contradicts the notes the jury wrote to the court during deliberations, the last of which expresses disagreement over whether the Commonwealth met its burden as to the elements of the charges. Emphasis added. We went over this at length too. You and me and Mark. Charges could have referred to count 2, which had several lesser includeds underneath the main charge of manslaughter. So I respectfully, or maybe not so respectfully, disagree, Your Honor. Even doing so, any agreements among the jurors as to count 1 and 3 cannot be considered acquittals for purposes of double jeopardy. So call them in and ask them. It's really not that hard. To trigger double jeopardy protection, an acquittal requires a verdict on the facts and merits. Commonwealth v. Brown. CGL 263, Section 7. A person shall not be held to answer on a second indictment or complaint for a crime of which he has been acquitted upon the facts and merits. And the only verdict which can be received and regarded as a complete and valid verdict of a jury is an open and public verdict, affirmed in open court as the unanimous act of the jury and in the presence of the whole panel, so that each juror has an opportunity to express his dissent to the court in case his decision has been mistaken or misrepresented by the foreman or his fellows, or in case he has been forced into acquiescence by improper means. It's a 2015 case. I would argue that improper means could be a couple of people in the gallery staring them down during closing arguments, a couple of people who were pointed out as being potential third-party culprits. Could that have been like improper means to force them into acquiescence on a hung jury? On one of the counts? Maybe. Citing Commonwealth v. Zacharias. The verdict shall be unanimous. It shall be a general verdict returned by the jury to the judge in open court. The jury shall file a verdict slip with the clerk upon the return of the verdict. Where is the verdict slip? Have we seen it? Is it in the court file? Does anybody know? As such, the weight of final adjudication cannot be given to any jury action that is not returned in a final verdict, and a distinction must be made between agreement on a verdict and return, receipt, and recording of a verdict. Citing a Juvenile v. Commonwealth. We went over that case at length with Mark on the last stream. I'll link that last stream below because we went over the motion papers at length and the case law. Because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of the charges. The only unanimous act of the jury here was their representation to the court that they were at an impasse and unable to agree on whether the Commonwealth had established, beyond a reasonable doubt, the elements of the charges. The purported later attestations by some jurors after they had been dismissed that the jury had in fact agreed on some of the charges during deliberations do not have the force of a final verdict. Citing Commonwealth v. Floyd and a Juvenile. After mistrial was declared due to a deadlock, judge did not err in refusing to accept signed verdict slips recovered from the deliberation room showing not guilty because it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. Yeah, but in this case, we don't have any verdict slips. And in that case, I believe also a Juvenile, there was only one count. And they found the slips like in a garbage pail, like a long time afterward or sometime after. It wasn't the jurors that came forward. See also Bluford v. Arkansas. Double jeopardy did not bar retrial after hung jury where a four-person reported unanimous vote on offense before deliberations had concluded, but deadlock at conclusion. We went into Bluford at length as well on the last stream. The defendant argues that it is elevating form over substance to not accept that the statements in the affidavits reflect an acquittal of the defendants on counts 1 and 3. However, the rendering of a verdict in open court is not a ministerial act, as the defendant contends. Rather, it communicates the finality of the deliberations, and its pronouncement in open court ensures its unanimity. See a Juvenile. Public affirmation in open court provides safeguards against mistakes. Indeed, the authority upon which the defendant relies places particular importance upon the jury's pronouncement of its findings in open court. See Bluford, in which Judge Sotomayor dissented, arguing that the forewoman's announcement in open court that the jury was unanimous against conviction on capital and first-degree murder was an acquittal for double jeopardy purposes. Footnote 5. In written and oral argument, the defendant also relies on language from Taylor. Taylor discussed whether a judicial determination to terminate proceeding based on a procedural ground implicated double jeopardy. The Supreme Judicial Court explained, what constitutes an acquittal is not to be controlled by the form of the judge's action, and that the determination does not depend on check marks on a form. This language in Taylor does not inform the court as to the circumstances here. Thus, a verdict in substance is a final collective decision reached after full deliberation, consideration, and compromise among the individual jurors. And when that decision is announced in open court, it becomes entitled to full double jeopardy protection. Emphasis added. Citing Commonwealth v. Ross, declining to give effect to the verdict received from the lips of the foreman in open court would elevate form over substance. Where there was no verdict announced in open court here, retrial of the defendant does not violate the principle of double jeopardy. Well, to be fair, you didn't ask if they had reached a verdict on any of the counts, and you told them not to fill out the slips till they were unanimous and decided on everything. That's what some of the affidavits of some of the jurors said. They were confused. They didn't understand why you didn't ask them when you went back and talked to them. They were talking about it on the bus. That's why they came forward right away, the next day. Section 2, manifest necessity of mistrial. Thank you, Justin Green, for the Cash App, as always. Love you. The defendant's motion to dismiss also argues that double jeopardy bars reprosecution because she did not consent to a mistrial and there was no manifest necessity to declare one. This argument, too, is without merit. Quote, a defendant's consent to a mistrial removes any double jeopardy bar to retrial. Citing Pellegrin v. Commonwealth, consent may be explicit or implicit. Explicit consent may occur by either moving for a mistrial or agreeing to one. Commonwealth v. Edwards. Consent to a mistrial may be implied where a defendant had the opportunity to object to a declaration of a mistrial and failed to do so. Pellegrin, CUS v. McIntosh, where the defendant sits silently by and does not object to the declaration of a mistrial, even though he has a fair opportunity to do so, a court may presume his consent. See also United States versus U, 2004 case, cert denied in 2005. The court may infer consent only where the circumstances positively indicate the defendant's willingness to acquiesce in the mistrial order. Citing US v. Goldstein, consent to a mistrial need not be expressed, but may be implied from the totality of the circumstances attendant on a declaration of a mistrial. As noted, the court here declared a mistrial after the jury reported 3 times that they were deadlocked. After the second time, the court determined that the jury had engaged in due and thorough deliberations and gave the WE Rodriguez instruction before sending the jury to deliberate further. Massachusetts General Law 234A, Section 68C, provides that if a jury, after due and thorough deliberation, returns to court without having agreed on a verdict, the court may state anew the evidence or any part of the evidence, explain to them anew the law applicable to the case, and send them out for further deliberations. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent unless they ask from the court some further explanation of the law. See Commonwealth v. Jenkins. If, after due and thorough deliberation, the jury twice advised the judge that they are unable to reach a verdict, the judge may not properly send the jury out again without their consent unless the jury asks for some further explanation of the law. You are correct, Mama Smith. The SJC ruled against Bev on getting Jen for McCabe's phone records. That's right. They had to appeal that, and it went to the SJC. And she was overturned. In their notes to the court, the jury specifically stated to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs, making it clear they would not consent to continuing their deliberations. Attorney Yannetti twice argued for the court to give the WE Rodriguez instruction, the final step before the court would declare a mistrial. See Jenkins and Ray v. Commonwealth. Counsel's request for WE Rodriguez instruction permitted the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. Specifically, on Friday, June 28th, 2024, after 3 days of deliberations, when the jury sent their first note indicating they had engaged in an exhaustive review of the evidence and had been unable to reach a unanimous verdict, Attorney Yannetti argued that the jury had engaged in due and thorough deliberations, was at an impasse, and should be given the Tui Rodriguez instruction. The following Monday, when the jury sent a second note after deliberating for approximately 2 hours, stating that consensus was unattainable, Attorney Yannetti again argued that due and thorough deliberations had occurred and described the jury as hopelessly deadlocked. Defense counsel, in arguing twice that due and thorough deliberations had occurred and pushing for the instruction, presumably was aware of the legal implications if the jury returned deadlocked again. Nevertheless, in a remarkable turnaround, defense counsel now argues that the result they twice advocated for was sudden and unexpected. See defendant Karen Read's motion to dismiss at 8. The court is calling this a remarkable turnaround. Although the court did not specifically ask defensal if they had any objection to the declaration of a mistrial, she's actually admitting that here. Counsel had multiple opportunities to voice an objection if they in fact had one. While waiting for the jury to enter the courtroom after the court announced the jury was again at an impasse on the afternoon of July 1 of 2024, defense counsel could have asked to be heard on the issue, blaming the defense once again. During the subsequent discussion about scheduling a status hearing right after the court declared a mistrial, counsel had yet another opportunity to inform the court of its dissatisfaction. Lastly, counsel could have communicated to the court any objection or request to poll the jurors while the jury was still at the courthouse waiting in the deliberation room after the declaration of the mistrial. Now she's saying that defense counsel could have asked for a poll? That's interesting. I thought that's not the way we do it in Massachusetts. Instead, defense counsel said nothing to the court about the mistrial and then proceeded to the courthouse steps, where Attorney Jackson declared to the media and onlookers that the Commonwealth failed miserably and will continue to fail with its prosecution of the defendant, footnote 6. And then there's a YouTube link to that quote. And here's where I think the judge might have watched me before. It strains credulity, she says. It strains credulity. I have merch. I've had merch for a long time. It's linked to this video. It strains credulity to believe that if defense counsel wanted to voice any objection to the court, it would not have been heard. Significantly, defense counsel were no shrinking violets. Neither Attorney Jackson nor Attorney Yannetti has ever needed this court to inquire whether counsel had an objection in order to be heard, and the court has never denied counsel the opportunity to be heard in open court or at sidebar. Contrast with Mr. Lally, would you like to object? Mr. Lally, do you have an objection? Mr. Lally, do you have an objection? Do you have an objection? Strains credulity. And that, wow, just wow. We have a wow emoji. We have a wow emoji. Members, let's see a wow. And a sigh. And a nope. And by the way, so much stuff was discussed at sidebar that we have no idea about that because we weren't privy to it. Which is unlike so many other trials that we watch where things are argued in open court outside the presence of the jury. The court reconvened many times at counsel's request. You know what strains credulity? This decision. This decision strains credulity, but we'll get there. Just days before the declaration of a mistrial, defense counsel asked to address the court while the jury was deliberating to raise an objection about the verdict slip. Attorney Jackson was not shy in informing the court that he wanted to make his argument and that the court's decision about the verdict slip was not how it should be, and it's over our strong objection. Footnote 7, which is another YouTube link. Attorney Jackson went so far as to suggest that it was almost like the court is directing a verdict of the subordinate charges by not making the changes he wanted. The court finds it hard to believe that when counsel heard that the jury was at an impasse for a third time and a mistrial was inevitable, at perhaps the most crucial point in the trial, counsel would sit silently if they did not consent to a mistrial. Say you. As such, the court does not credit Attorney Jackson's averment that he lacked an opportunity to be heard. Okay. So she believes everything the jurors said in their affidavits, but too bad. And Mr. Jackson, I just don't believe you, Mr. Jackson. Defense counsel's silence, despite ample opportunity to be heard, is deemed consent. See Pellegrin. When trial judge on its own initiative declared a mistrial, defendant's silence was deemed consent where there was ample time to object, despite not being directly asked by the judge. Commonwealth v. Fetsaya. Silence was not consent where the judge's conduct was so intimidating as to defense counsel. Silence was not consent where the judge's conduct was so intimidating to defense counsel as to foreclose any objection from defense counsel to the declaration of a mistrial. Even assuming arguendo, the defendant here did not consent to the mistrial, the law is clear that a retrial is permissible so long as there was manifest necessity for the mistrial. Citing Taylor, the trial judge's belief that the jury is unable to reach a verdict has long been considered the classic basis for a proper mistrial. Because the court here had no doubt, based on the jury's notes to the court, that it was unable to reach a unanimous verdict, and the jury represented to the court that continued deliberations would be futile, there was manifest necessity for the mistrial based on the deadlock. As stated above, the foreperson on behalf of the jury in this case sent the court 3 notes, none of which indicated agreement on any of the charges. I'm going to break from the document to tell you, you told them not to. We've played it back several times. In the first note, the jury wrote that they had been unable to reach a unanimous verdict. In the second note, they stated that they were deeply divided by fundamental differences in our opinions and state of mind, and that consensus is unattainable. In their third and final note, after they had been given the WE Rodriguez instruction, the jury stated that they continued to be at an impasse. They described themselves as starkly divided on their perspectives of the evidence, explaining, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. The only reasonable interpretation of these notes, and specifically the final note, was that the jury could not agree on any of the 3 charges and further deliberations would serve no purpose. I disagree. That's the only reasonable interpretation of these notes. Wouldn't it also be reasonable to interpret that charges could mean all of the charges in count 2? Couldn't that also be reasonable? I think it could. Footnote 8. Given the care that went into writing the notes and how articulately they expressed the jurors' disagreement, it strikes this court as odd that there was no inkling of an indication of agreement in the context of the notes, or that if the jurors were uncertain whether they could return a partial verdict, they would have not asked the court. I'm also going to point out that the foreman was chosen by you before the alternates were even selected as juror number 1. So they were very intelligent notes, I will agree. But also, the foreperson, I'm going to suggest, was smart enough to know they were going to be read in open court, and you told them not to return a verdict until they had agreed on all 3 of the counts. He was just following instructions, perhaps. I think it was a he, the foreperson. You can correct me if I'm wrong on that. For the defense to now claim that the notes were susceptible to different interpretations, such that the court should have inquired further, rings hollow, particularly where Attorney Yannetti had twice argued that the jury had engaged in due and thorough deliberations and could not agree. See U.S. v. Keene. No abuse of discretion in declaring a mistrial, given the increasingly adamant manner to which the jurors announced that they were deadlocked. Moreover, defense counsel's conduct immediately after the declaration of the mistrial in no way suggests that they thought otherwise. Again, blaming defense counsel. The defendant contends that the court failed to carefully consider that as an alternative to a mistrial, it could have simply asked the jury to specify the charges on which it was deadlocked. Defendant Karen Reed's motion to dismiss at page 8. However, the question whether a mistrial is appropriate in the circumstances of a given case is not answered by application of a mechanical formula. Citing Ray, quoting Illinois v. Somerville, see Commonwealth v. Bryant, decision whether to declare a mistrial is within the discretion of the trial judge. She loves her discretion. Rather, the court considers several facts, such as the statements in a jury's note concerning their ability to reach an agreement, the time spent in deliberation, and the length and complexity of the trial. Citing Renico v. Lett, we have never required a trial judge before declaring a mistrial based on jury deadlock to force the jury to deliberate for a minimum period of time to question the jurors individually, or to consult with or obtain the consent of either the prosecutor or defense counsel to issue a supplemental jury instruction, or to consider any other means of breaking the impasse. Where here the jury had been deliberating for 5 days, had not returned to the court. Wait 1 second. Where here the jury had been deliberating. Hold on. Getting parched over here. I'm getting parched. It's making me mad. Where here the jury had been deliberating for 5 days, had returned to the court 3 times, stating they could not agree, and had been given the WE Rodriguez instruction, and returned hours later with a note plainly indicating that they could not agree as to the, quote, elements of the charges, and that to continue to deliberate would be futile. Asking the jury on which charges they were deadlocked was not necessary to determine that there was manifest necessity for a mistrial. See Fuentes v. Commonwealth, where final note from the foreperson unequivocally stated that the jury were unable to come to a unanimous decision. Judge was not required to inquire whether there was any reasonable probability of unanimous verdicts or if the jury would consent to further deliberations. Citing Ray, judge did not err in declining to poll the jury on whether further instructions or deliberations would be likely to resolve the deadlock. Moreover, the defendant's argument ignores the fact that 1 of 3 charges had lesser included offenses. Therefore, if upon questioning the jury had indicated to the court that they were not deadlocked on all of the charges, the only option would have been for the court to send the jury back for further deliberations. See a juvenile. Judge should not inquire as to partial verdicts on lesser included offenses. Such action would be improperly coercive under the circumstances. It has been repeatedly recognized that deadlocked juries are particularly susceptible to coercion. Where the jurors have twice reported themselves deadlocked, this is citing Roth, and I've already heard the WE Rodriguez charge, a judge's inquiry concerning partial verdicts cannot avoid communicating to the jury the judge's desire to salvage something from the trial. Where here the jury had before it one indictment which included lesser included offenses, had 3 times reported themselves deadlocked on separate charges, had already heard the Tui Rodriguez charge, and had sent a final note indicating that continued deliberations would only serve to force them to compromise their deeply held beliefs. Sending them to deliberate further would have been improperly coercive. Okay, they're not arguing that you should have sent them back to deliberate further. They're arguing that you should have simply inquired as to whether they were able to reach a consensus or a verdict on any of the counts. That's different. Footnote 9. It is the court's view that under these circumstances, even posing the question to the jury of whether they actually were deadlocked would have implied to the jurors that the court wanted them to resume deliberations to reach a verdict. Given that Attorney Jackson had already expressed concern that the court was directing a verdict of the subordinate charges, the court was extremely cautious to not give any appearance of partiality. Really? So that's the one time that the court was extremely cautious to not give any appearance of partiality. The one time. Given that Attorney Jackson had already expressed concern that the court was directing a verdict of the subordinate charges. So that's when you choose to be. That's when you choose to be extremely cautious. That's rich. That's rich. The defendant's argument suggests that questioning or polling jurors who report a deadlock is the best practice, or at least commonly done by trial judges. However, the defendant has not cited any cases saying as much, and indeed, such an inquiry is not undertaken in the regular course. She admits that now. It's not the way we do that in Massachusetts. And I guess in my opinion, maybe there's no case on point because it's never happened before. It's never happened before. And sometimes when you're a judge and it's never happened before, you have to have the conviction and justice to actually maybe change the law or make new law if there's not a case on point. Because apparently the Commonwealth couldn't come up with a case on point either. Footnote 10, the defendant relies on Commonwealth v. Foster and Commonwealth v. LaFontaine to argue that there would be nothing coercive about asking a jury reporting a deadlock whether they had reached a unanimous verdict on any of the counts, because neither the jury in Foster nor the jury in LaFontaine reported being deadlocked in its deliberations, and none of the offenses charged had lesser included offenses. There was clearly no risk of coercion in the court seeking partial verdicts on the separate indictments in those cases. The circumstances here are markedly different. For a judge to make such an inquiry on her own accord could impede the strategic decision of counsel to not make such a request. The defendant's argument is based on hindsight. No one other than the jury knew that questioning the jurors as their deadlock would have yielded a favorable outcome for the defendant. It is likely for that reason defense counsel consented to this court's declaration of a mistrial. Roman 3, post-trial inquiry. The defendant alternatively requests that the court allow counsel to conduct a post-trial inquiry of the jurors to substantiate the existence of an acquittal. Defendant Karen Reed's motion to dismiss at page 9. Such an inquiry is impermissible. The defendant's argument relies solely on Commonwealth v. McCallop, the 2020 case. In McCallop, the Supreme Judicial Court held that the trial court should have allowed the defendant's motions for jurors' names and contact information based on the post-trial statement of a deliberating juror regarding racist statements made during deliberations. The SJC explained the presence of even one juror who is not impartial violated a defendant's right to trial by an impartial jury. Recognizing that racial bias in the jury system is a familiar and recurring evil that, if left unaddressed, would risk systemic injury to the administration of justice, the McCallop court held that the defendant should have been given a fair opportunity to obtain an affidavit from that juror, setting forth with some specificity who among the jurors made statements reflecting racial bias and the statements that were made. You remember we went over that case, and that is the defendant that is sitting in jail for the murder of Krista Worthington from Cape Cod, very long time ago, who swears that he's innocent. The defendant's argument here does not implicate racial bias or her right to receive an impartial trial. Thus, the reasoning the court employed in McCallop does not extend to this case. See Commonwealth v. DiBenedetto, declining to extend racial bias exception to the inquiry of jury unanimity because infection of the criminal justice system with racial or ethnic bias is a unique type of constitutional deprivation that requires a vigilant response, not warranted in the circumstances presented here. The defendant's request effectively seeks permission from the court to inquire from deliberating jurors that which is impermissible, information regarding the substance of the jury's deliberations. No. It's not the substance of the deliberations. It's not how did you come to this decision. It is, did you agree to acquit on count 1? Did you, yes or no? Did you agree to acquit on count 3? Yes or no? That's not substance. The secrecy of jury deliberations has served as the bedrock of our judicial system, and inquiry into the jury's deliberative processes would intrude improperly into the jury's function. Said in Commonwealth v. Moore. It is simply not the case, given the content of the jury's final note to the court, that any inquiry to jurors now could be limited solely to the results of the deliberative process and not implicate the process itself. Again, I disagree. Any inquiry would necessitate. Any inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on the charges when post-trial certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges. No. You don't have to understand why at all. There's no why. It's a yes or no question. There's no why involved here. There doesn't need to be a why involved here. While the defendant contends that the conflict is reflective of the fact that the instructions given to the court jury by the court were confusing, determining whether this is true would necessarily require inquiry into the back and forth among the jurors during deliberations. No. Again, it's a yes or no question. You don't need to decide. You don't need to ask the jury whether they thought the instructions were confusing. That doesn't need to be part of your inquiry. It's a yes or no question. See DiBenedetto. The judge is precluded from inquiring into the internal decision-making process of the jury as a whole or the individual juror being questioned. Alternatively, evidence that jurors misunderstood the instructions of the presiding judge cannot be considered. Thus, such an inquiry is prohibited. The defense counsel has not cited one case suggesting the post-trial inquiry they now seek is appropriate or that it could change the outcome of the proceedings. Footnote 11, which says, cases that defense counsel referred to at the hearing on this motion concerning post-trial inquiry of jurors where juror bias or outside influence was at issue are readily distinguishable from the circumstances here. For the reasons already discussed, an acquittal of the defendant now on indictments 1 and 3 based on conclusions purportedly reached during the jury's deliberations is not possible. Therefore, there is no reason for the court to allow post-trial inquiry of the jurors. See a juvenile. No error in denial of motion to subpoena the foreman, where process would only serve to impeach jury's report to the juror in open court. Conclusion and order. This court recognizes that the bar on retrials following acquittals is perhaps the most fundamental rule in the history of double jeopardy jurisprudence. However, where there was no acquittal on any of the charges in the defendant's first trial, there was no risk of subjecting the defendant to double jeopardy by retrial on all of the charges. Therefore, the defendant's motion to dismiss is denied. Signed, Beverly J. Cannoni, Justice of the Supreme Court, dated August 22nd, 2024, and filed today, August 23rd of 2024. But Your Honor, we don't know if there was an acquittal unless you actually ask the jurors, because more than 1/3 of the jury has come forward to say that they did in fact acquit her on 2 of the charges. So are we looking for justice, or are we just looking for a conviction? You know my opinion on that. And now I'll tell you Mark Bettero's opinion on that since he's on vacation. Mark Bettero says, I knew you would all want to know. So I said, give me a quote. Give me a quote so I can read to the people, to our people, to my people, to you amazing people, what you think. Because everyone's going to say, well, what does Mark think? Here's what Mark thinks. Just another example of form over substance, falling back on how things are done. Why not bring the jurors in and see if a unanimous verdict, and then find out, so if so, why they didn't inform the court? We're talking about a fundamental constitutional right. Massachusetts is one step closer to trying an acquitted woman for murder. Now all the pressure is on the DA. This is a disaster for them if they don't dismiss the murder count. Every prospective juror will know that they are trying an acquitted woman, and prepare for more jurors to speak out and clear their conscience. What say you? I'm going to tell you briefly after this what the anonymous juror said to Aidan Carney in an interview. Amy in Boston says, in my opinion, Bev was a coward. She didn't want to be the one who allowed the defense to get what they wanted. I'm outraged. The Norfolk County DA's office can go F off, as she says. Thanks, Amy. Susie, thanks for becoming a new member. New Hampshire woman says Bev needs to retire to the Cape. Thank you, New Hampshire woman, for chiming in here. Debbie Blair said, defense did have an opportunity to say anything. She said mistrial. Didn't, I think you mean to say. Didn't have an opportunity to say anything. She said mistrial and scrambled off the bench. Perhaps this was on purpose, so the defense couldn't say anything. Don't know. Thanks, Chris, for becoming a new member. Hi, Nina, again. Isn't it better to get a new trial instead of a guilty verdict for manslaughter? The state's case is even weaker next time. I agree. Their case is getting worse and worse and worse, especially with each new law enforcement officer on this case who's being internally investigated. Proctor, Buchanan, Tully. What is better? I'm a constitutionalist, right? So double jeopardy is a thing. And if they did actually acquit on 2 of the counts, you could at least call them in and ask them. It's not that burdensome. It's not that difficult. It's not that burdensome. And isn't that what justice requires? But instead, she'd rather just wash her hands of it, send it up to the appellate court. So that what? So the appellate court can send it back down to bring the jurors in and question them? How much time will have passed by then? I mean, it's already been, the verdict was, the mistrial was declared, was 2 months ago. And the jury's been out reading social media and learning so much more about the case, and they must be outraged. They must be outraged. Thanks, Laura, for becoming a new member. This is Bucket for your super sticker. Bees on Mars, thank you for the 20, says, this is about the jury. Fixating on the defense is wrong, right? And that's what she did. Take it from me, a whole entire black woman avoiding double jeopardy is just as important to me as avoiding racial bias. Agreed. I agree with you. Bev is outrageous. Bees on Mars, thank you for your super chat, and I am in full agreement. I mean, what are we doing here? What are we looking for? Micro Dots, thank you for all of your amazing work and for watching and for chiming in with a 10. I understand the desire to stay anonymous, but how would they live with themselves if she was eventually in prison, knowing she's innocent and they could have spoken louder? Yep. After this decision, they may change their minds, right? I mean, isn't that a possibility here? That's what I think. Oh, they bet this Wi-Fi here better not cut me off. Okay, let me know if I start glitching on you. So Aidan Carney got an exclusive interview with a juror who wanted to remain anonymous pending the decision. And you can go to his website and you can find it. And this juror answered a bunch of questions, including, had you ever heard of this trial before being picked for the jury? She said, I'm sure I heard about it when it happened, but it seemed to be another story like others you see on the news. I didn't pay more attention to this than I did anything else. I'm going to just pick some pivotal questions here that I thought were important. And one of them was whether or not they knew about the ARCA witnesses and the FBI. But here he asked, what witnesses did you find the most compelling? And this juror said, the medical examiner. I felt she was a straight shooter, gave her opinion based only on the facts. There was no point where I felt her opinion had been influenced by either the Commonwealth or the defense to fit a theory being presented. Who do you think were the most pointless witnesses? Or who do you think was the most pointless witness? The juror says pointless. The two women that were in Aruba with John and Karen a few weeks prior to January 29th. And then expounds on the answer, saying unnecessary. John's niece and nephew. I didn't see any reason why the children were brought into a courtroom to testify after all that they had been through. Could be that they wanted to be heard, but it felt wrong to have them on the stand with everyone watching. Here's another question. Brian Albert, Brian Higgins, and Michael Proctor all greeted the jury and thanked them after their testimony. What did you think about that? This juror said, these three men were a huge focal point of the trial. So while I wish I could have taken it as nothing more than a polite gesture, I did not. What did you think of Jennifer McCabe's testimony? I found Jennifer McCabe to be very combative, which was off-putting. Her demeanor made it difficult to process anything she was saying. Something felt off when she continued to ask to be reminded of statements, events, etc., with evidence of her prior accounts. It felt like she needed reminders of what she had previously said before she answered to keep from contradicting herself. Did the jury have any idea about the federal investigation? The juror said, perhaps others caught on, but I honestly had no idea. I missed Ryan Nagel mentioning the feds during his testimony, and I assumed the other proceedings were another grand jury or something like that. I had no reason to think that there was something as big as a federal investigation going on outside of the trial. How could anyone on that jury think that Karen Read hit John with her car after hearing from the ARCA guys? I can only speak for myself, but you have to understand that we were not told where these witnesses came from. There was a lot of conflicting testimony throughout the trial, specifically regarding IT and accident reconstruction experts. I understood that neither the Commonwealth nor the defense hired them, but I had no idea where they came from. For all I knew, they were two very smart and well-educated people who read about the case online and decided to analyze what happened. I found them credible, but there were things that they weren't aware of that I thought were important, and I couldn't understand why they were testifying when they didn't seem to have all the information. The positioning of their presence and the information they had been provided to analyze was strange, no doubt, but being hired by the FBI or any other agency never crossed my mind. How did you feel about Brian Albert being in the courtroom for closing arguments? For closing deliberations, closing arguments. I felt it was inappropriate. He was a key witness and a major focal point during the trial, so I don't think he should have been allowed in the courtroom at any time other than during his testimony. This goes for Jennifer McCabe and Colin Albert as well. There are other questions there that this juror answers, and I suggest if you would like to read the whole thing to give Aidan Carney full faith and credit for his reporting, And the fact that this jury decided to speak to him instead of mainstream media speaks to his effectiveness, I think, as a journalist. And I'm not on Twitter, but if you go to Twitter, I think you can find it there. Or if you are a member of his website or his YouTube channel, I'm sure you can find it pretty easily. And interesting, right? So off we go to the appellate court, my friends. Off we go to the appellate court. Mrs. Bucket says Troopers Paul Proctor cannot surely be prosecution witnesses, and I think the McAlbert's staring at the jury in closing was just wrong. I think you're not alone. He has it on YouTube. Thank you, Archangel807. I appreciate you and your amazing support for everyone who has covered this case and this trial. We have been relentlessly attacked for having nothing more than opinion. My opinion has been, since I started covering this case in January and during my court TV appearances, that based on my professional experience as a trial lawyer and litigator, 30 years, handling hundreds, if not thousands, of motor vehicle accidents, including pedestrian cases, that Officer John O'Keefe was not hit by a car. He just was not hit by a car. It's as simple as that. It is as simple as that, in my opinion. And I am outraged, and you are outraged. And if you live in Massachusetts, you should be outraged, because this is just another example of your constitutional rights being placed under attack. And now there's a defendant who is, by all accounts and facts, not guilty, being forced to incur the expense of being retried again, at least on one count, because we don't know what the appellate court is going to do. And if our system is based on fairness and justice, where is that? Where's the fairness and justice here? She had an opportunity to do the right thing. She didn't do it. So I agree. It was a terrible thing to have them there. Right. We base our opinions on facts, not feelings. Right. Meyer says it's strange it wouldn't have crossed their minds about the FBI. There was a near miss or two. Yeah. Apparently she or he, whoever this witness was, didn't catch it. And I'm sure they cannot speak for the other jurors. So that girl T says she's disgusting and the government's corrupt. We're watching it in real time with no way to stop it, and I am outraged. I mean, I really kind of thought she would do the right thing this time and at least call them in. At least call them in, inquire, and then render your decision. Then decide what to do. Now the ball is in the DA's court, and I just don't think that the DA is going to dismiss the charges. There's too much ego here. Think Michael Marcy's going to dismiss the charges? Harmony, I can't afford a super chat. Sorry, no worries. Will they be able to let the next jury know that ARCA witnesses were brought in by the feds? I don't know. We'll see who if there is a retrial, we're going to see who the trial judge is going to be. If it's still going to be Judge Cannoni, she already ruled in the first trial. They are not allowed to know. And so I wouldn't see any reason why she would reverse herself on that decision in a retrial. So that I find to be interesting. Yes, Carol. They thought maybe the insurance company did it. And didn't I say that? I think at one point I said, maybe they think that if there was a car accident, if there was a lawsuit by the estate against Karen for the car accident, the alleged car accident, were they hired by the insurance company? Maybe that's what they're going to think. Right. Risa says she hates Alan Jackson. It makes me so mad. So mad. I love that guy. And Mr. Yannetti. They are so classy. Bev is just not a credible person, let alone judge. I mean, I think the decision clearly makes her bias against the defense counsel, kind of a little bit more obvious than it was before. I know all of you have been screaming about it for a very long time. Gregor says, zero due diligence. And as Mark says, kick the can down the road. Is this just her punting? So she's not held accountable, given that letter from the U.S. Attorney General? Perhaps. Perhaps, but why not call the jury? What's the downside to calling the jury in and just inquiring anonymously? It doesn't have to be on television. You can bring them into chambers with both attorneys and just ask them one by one. The day that I was in court and Mark was in court, June 14th, they called several jurors up to the bench to be questioned at sidebar by the attorneys and the judge. And at the end of that day, one of the female jurors was dismissed. So it's not like they haven't inquired of the jurors before, during the trial, brought them in and talked to them. What's the harm? Well, thanks, Kelly, for the 10. You didn't need to do that. Our family is blessed to have all of your support, especially you, Melanie. Free Karen Read. And to every one of you who tirelessly is out there fighting for justice for a woman that you do not even know. And it's nationwide and it's worldwide now. And I saw something, if you guys want to put in the chat that there's going to be, I think Labor Day, is it Labor Day that you're going to be having nationwide standouts? And there's a website for that. And if somebody would drop that in the chat, I am happy to put it up on the screen so that any of you nationwide, or I think even worldwide, can go stand out for justice. We're watching another trial right now, the case of Robert Tellis, who was a public official, politician, and attorney in Las Vegas, who claims he was being framed for the murder of an investigative journalist, Jeff Gehrman. It's a very different case. And there's nobody outside with T-shirts for him fighting for his justice because, quite frankly, the guy is dead to rights, probably guilty. And we're going to continue with that trial right after this. So if you haven't been watching that, it's been a great palate cleanser trial for us because so many people were so outraged with the system between Karen Read's case and Ashley Benefield's case that we needed something lighter. And yesterday's testimony was hilarious. And I suggest you watch it. If you haven't, I'm going to teleport everyone over to the noon stream on that trial after we wrap here. Thank you, Kelly. And prayers up for your family because this is like the fight that will never end. And I can't imagine what you're all going through. And we're outraged. We are outraged. John Monagle. Whether or not the jurors are brought back to be questioned about a verdict, the verdict should not have been left to the same judge who oversaw the trial. It needed a neutral party review. That's what the appellate court's going to do. But as of right now, she's in charge of all the post-trial motions, just like she was in charge of all the pretrial motions, including the motion to recuse herself. In the Tellis trial, the one that I just told you about that we're covering, that defendant was pro se for a bit in Nevada, and he made a motion for the judge to recuse herself, and it was decided by a different judge. So just another example of the reason that Massachusetts laws need to be changed, and the jury instructions need to be changed, and they need to be more clear. And you can't tell a jury, okay, I'm going to give you the written instructions to bring back with you, but I'm also going to tell you some stuff. And if what I tell you conflicts with what's on the page there, disregard that and go by what I said and your notes. Okay? Bees on Mars says, to me, it didn't matter who hired the crash daddies. They came with science, not opinions. Yep. Thank you, Mrs. Bucket. It's late in the UK. Lila Ward is embarrassed of our judicial system. Mac Dickles. Melanie, it's the Commonwealth that God can't even hope. God save the Commonwealth. And there's a man passed out in the snow. God can't even hope to save the Commonwealth, says Mac Dickles. Career public servant grifters and lifetime appointed hacks never do the right thing. Jebby Canfer says Judge Cannoni's too entangled with the Albert family. She should have recused herself. I have a pretrial show on that motion as well. If you haven't watched it, go back and watch it. We did that at length, and I agree. Look, even if she never rented out her Cape house to the Nagels, and that Venmo spelled her name wrong, and that she doesn't know anyone named Sean McCabe, whose seaside cottage Sean McCabe threatened to bury Aiden Carney's body under, she had the opportunity to say, look, I don't know any of these people. I don't know what this Venmo's about. I don't spell my name with an EY, but because I want to avoid the appearance of impropriety, I don't even want to make it look like I have any bias or that I know any of the players involved here. And therefore, I'm going to step aside and go back to civil court and let someone else handle this. There was an opportunity there. Obviously, it was not taken. And there is that. Yeah, there is no downside. That's why this stinks. And that's the downside. As Galige says, because the jury found Karen not guilty on 1 and 3. Yeah. Higher Truth Art is heartbroken that Karen has to go through this and is outraged. Yep. Richard Johnson says the downside is that the Commonwealth would look bad, and Bev has been protecting Lally the entire trial. Do you have an objection, Mr. Lally? Witness, can you answer that? Can you answer that? John Monagle says, the downside to calling the jury back is they will find out Karen was acquitted. Marcy cannot allow that. He must protect the McAlberts at all costs, going all the way back to the hostage video that he made. Chloe Albert's revenge, thanks for the 10. Amazed how these people can still think the ARCA guys should have had all the extraneous, all that extraneous info. Mathematically, the car accident is impossible. Case closed. Cars hit people before they had black boxes. Yeah. And it wasn't necessary information for them to reach their conclusions. I thought that they made that clear, but I'm also a litigator. So maybe I have a greater understanding than an average juror. Maybe. I mean, the only upside to retrying this case is the defense has learned which points they need to hammer home a bit more. This case was long. It was convoluted. It was a mishigas. It was completely, the prosecution's case was all over the place, and it was confusing for anyone to follow. And those of us who knew so much about the case already had an easier time following it because we knew what we knew, but the jurors didn't. Trevor, thank you. Bev gaslit all of us with this ruling and her statements. Shaking my head. Thank you, Trevor. I'm just a girl in the world. Says thanks for keeping us all so well informed. Thank you. Thank you guys for watching. We're here and we're venting with each other together. I'm just looking to see if you guys put anything about the Labor Day standouts in here. I think there's a, yep, Karen could be any one of us. That's true. She absolutely could be. That's right, Amy in Boston. Bees on Mars says no downside. The jurors were questioned in open court in the Murdoch trial. The jurors were kept anonymous and the court got answers. If you're interested in justice, you find a way to do it. Yeah. And that was a little bit different because those jurors were possibly influenced by the clerk of the court, Miss Becky Hill. And the Supreme Court of South Carolina has decided to hear that case. They're leapfrogging the middle court and going straight to the Supreme Court. And in my opinion, thanks, Kelly, Alec Murdoch will likely get a new trial based on the tampering of the jury by the court clerk. Yep, deny. It strains credulity. Everybody loves you, Kelly Reed. I am sure that the appeal is being drafted, if not done, and will be submitted shortly because the defense is not going to wait 7 weeks to get that filed, or 77 days, as it took Judge Bev to decide on some of the pretrial motions. Yep. Good morning, Aeon. This is bigger than Karen Reed and always has been bigger than Karen Reed. Yeah. Because Karen Reed could be you. Karen Reed could be me. Karen Reed could be your sister, my sister, your daughter, your niece. If this can happen to the Karen Reed, it can happen to any one of you or us. If Karen Read didn't have the means and the financial backing to defend herself, she would have been sitting in jail since January, whatever day she was arrested first, February 2nd, 2021. Uno momento. Christina Rex is reporting. Attorney Marty Weinberg, who argued this motion on behalf of Read, says, we have a statement, breaking news. We respectfully but strongly disagree with the cornerstones of today's rulings and fully intend a vigorous appeal to assert and uphold Ms. Read's rights under the Double Jeopardy Clause. As we knew Marty Weinberg would do. And you saw him argue in court. He is one of the most highly regarded attorneys in Massachusetts. He's an appellate genius. The appellate court is a panel of judges usually. It's called the SJC in Massachusetts. Archangel wants to recall Governor Healy. Your mom's like, if there's any free route, tell us people, I'd love to see it. Kelly Reed is thanking all of you. We ain't got no quit. We ain't got no quit. Aunt BB. Aunt BB's one of the OGs. Yeah, tell us what have the Straw Hat Brigade. Oh, thank you. Thank you, Jamie Heather, my Massachusetts attorney. Or perhaps you're an attorney in a different state, but you just know better. The Massachusetts Court of Appeals is first and then the SJC. So can they leapfrog the Court of Appeals and ask the SJC to hear it and then they have to get consent to hear it? Or do they have to get a decision from the Mass Court of Appeals before they can go to the SJC? I have questions, but we will find out because attorney Marty Weinberg is on it. Strains credulity. This whole thing strains credulity. This is the standout for Labor Day. Okay, did you put it in here? Thank you, East Maine. They made a statement. We just read it. Debbie says, so hard to fight the corruption that starts at the bottom. It's supported all the way up to the line, but the Karen Read team is here to fight for justice. Hi, Galen. Remember for 10 months? My goodness, it's just shocking. Okay, not shocking. Ugh. Oh, and thanks for gifting 5 memberships. And for those of you who received them randomly from YouTube, congratulations. I think you're going to like it here. Thank you, Estelle, for thanking me for my excellent coverage. I'm here for it. I've been here for it. We're all here for it together. Scott McGinnis says Massachusetts Governor Maura Healey is a hapless hack and useless. Rise Journey says, feel bad for Karen. Something horrible happened to him in that house. Mrs. Bucket says, we ain't got no quit. We ain't got no quit. Well, it seems that they're going to be standing us on Labor Day. So look around for that because I can't. It's hard for me to read the chat and talk to you guys at the same time. Thank you, mods, for keeping it classy. I am going to end this stream and teleport you over to the stream on the Rob Telley's trial. If you haven't seen it, come watch with us. He's on the stand. He is being allowed to narrate his testimony. We are starting that at 2 p.m. Eastern, so 7 minutes from now. Trooper Paul's IQ of 76 says Massachusetts is a mess. Coming from a dude in Minneapolis, that's saying something. Karen has never been allowed to grieve. You're correct. Well, thanks, Mac Tickles. I missed you guys too. I've been waiting to cover this case. You're my favorites. Don't tell the others. But you guys are so supportive and so amazing, so kind. And I met so many of you. I had the pleasure of meeting so many of you when I went to Dedham that one day in court, and you were so kind. And just the vibe there was so, that was before the counter protesters started showing up. Well, the vibe was just one of just, I mean, like overwhelming love. And those of us who have been there can attest to that. And Karen's family is awesome and kind and amazing, and nobody deserves this. Nobody deserves this. Tax pays Bev's tax for her to do the math. Yep. Thank you, Very Raven said, I admired your belief that Bev would not dismiss the motion, but in my heart, I kind of knew she would. I know you thought that. I was being optimistic, which I guess is the definition of insanity, you know? Expecting a different result, like maybe this time she's going to do the right thing, call them in and really ask them if they really did acquit, because we should not try anybody's twice for the same crime. We shouldn't. We just shouldn't. It's one of the tenets of our Constitution of the United States of America. And, isn't it like, I mean, like, this is where, like, our nation began in Boston, right? Thanks, God McGinnis. It's insane. It's insane. I know. I agree. All right, my friends. As I always say, thank you, moderators, for keeping it so classy today. And I know this is a very difficult case to cover and a highly charged, emotional one for so many of us. I'm going to teleport you now over to the telestream. Please come join us. It's a lot of fun. Just, be cool, be kind, be classy. It's not hard. I promise you, it is so not hard. It strains credulity. That was mine. I got merch. Had it forever, since before this case. Peace.